Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 135 of the podcast. Thanks for listening. Thanks for supporting me for the last, now going on 2.5 years. So I'm very excited about that. So we inch closer to episode 200. So I'm certainly looking forward to celebrating that when we accomplish that goal. As you know, in my practice, I do quite a bit of litigation. In fact, lately it's been more and more I get involved in litigation and also get involved in buy-sell agreements by businesses that buy each other. Somebody buys a business or sells a business. A good deal of my practice involves partnership disputes, and they originate from deadlocks. And that's what we're going to talk about today. Deadlocks in partnerships, what happens when owners can't agree. And if you recall episodes back, if you listened to me for a while, I talk about partnership agreement, I talk about bylaws and operating agreements. And when people go into partnerships, some of the mistakes that they make is that they don't draft a partnership agreement or an operating agreement. They just go in a handshake deal and they go into business. Inevitably, they have some disagreements along the way, and then at some point, somebody decides to sue the other partner. And my first question when somebody calls me with respect to a partnership dispute, do you have a partnership agreement? And the answer most of the time is no, we don't have one. Or we have something we downloaded from the web, or we have one piece of paper, have a couple of text messages or WhatsApp messages. We don't have anything else. So that is the first mistake that I see, which leads to a succession of other mistakes, which can end up in litigation. So today, I want to talk about that. Deadlocks can come for any different reason. And deadlocks is what it means, is you have two partners that are equally own the company, and then they disagree as to the course of action of the company. And I'll give you an example of that. An example can be you want to fire an employee, and the employee is not doing a good job, and you want to terminate an employee. The other partner does not want to terminate the employee because there's a source of friction there. A purchase of equipment that could be significantly higher in price. There's usually a larger purchase that is not in the usual course of running that business, can create tensions as to that partnership. Whether or not to relocate the business. Your lease is up, you want to relocate it, and one partner wants to stay, wants to renew that lease. The other partner wants to relocate. So that's a source of tension. A more common source of tension is when one partner decides to utilize corporate credit card for personal expenses. So it's another way of paying him or herself more than a regular paycheck that they have agreed upon. And I've seen examples of people going on cruises on the corporate credit card and inviting the family and and using that, and not telling the partner, and the partner finds out that was charged from the business when he sees the credit card bill. So, and that is a source of friction as well. So there are a lot of different, I can come on in terms of examples, but if you're in a partnership, if you're listening to this, you probably can think of one or two instances where you had, or more, where you had disagreements with your partner. A lot of them might be minor disagreements that can be resolved through a conversation, but sometimes it escalates. So what do you do in this case? So we talked about what is a deadlock, and clearly it's self-explanatory. Two people just cannot agree on something, and there's no way to resolve that. And it creates kind of a paralysis as to the company of what to do going forward. An example of that is also taking on debt. One partner wants to borrow money on behalf of the partnership, and it requires the signature of the second partner. The second partner does not want to sign the document to take on that additional debt or that credit line or that loan. and that becomes an issue. Uh, Distributions as well becomes an issue, what to pay for distributions. Uh, so what to do in this case? I think in this case, you have to have clear, what I recommend, first of all, is to have an operating agreement and to have a well-written operating agreement that you both can rely upon in the case there are disagreements, how to resolve them. And I've made this offer several times when I talk about partnerships. The we have an operating agreement questionnaire, which when somebody asks me to draft an operating agreement that I send out, and if you're listening to this today, you want a copy of that, happy to send it to you. It's basically a list of questions that I recommend the partners go through in determining and developing that operating agreement. And if you cannot get through those questions, you're sure you might not might be a good idea to be into the partnership, because there's simply conversations that I believe need to be had as to how the company is going to run. I'll give you a number of examples. One of them will be, what are the areas of responsibility? You have two partners. You can have an operating manager that runs the day-to-day operations, and then you have the manager that runs the sales team that handles the sales and marketing. What decisions are going to be made that are individual decisions for those owners to take and to make, and which decisions require both of the partners to have unanimous consent. That's just one example. Another example, how much to pay each partner. Are you going to draw salary from the company and on a payroll, or are you going to be taking distributions on a periodic basis, whether it's monthly or quarterly, and how those distributions, how the amount of distributions will be determined. It's going to be determined by the sales coming in. It's going to be determined by the amount of working capital that you have. Those are conversations that need to be had in order to really have a good partnership. Because you will have those conversations where you're going to have them before, or you will have them when the issue happens. So this is a few examples. Whether to purchase, what decisions you can make. You want to purchase a major piece of equipment for the business. Who can make that decision? And does that require both partners to agree? Decisions on taking on loans. And this is very important. I've had situations where one partner takes a loan for the company, does not tell the other partner. And in some cases, banks will not require both signatures. One manager can sign, and then the partnership has that, the business has the debt. And that debt has to be paid. You have debt services to be paid as well. And what is that money going to be used for? That is very critical. So those two conversations need to take place in order to avoid partnership disputes and deadlocks, which can lead to litigation. Who can sign contracts and for how much? And I've given this example before. I mean, if you're going to need to, just to give an example, going to Office Depot buying office supplies, people now buy them mostly through Amazon. They didn't go online, but you need to buy something that is customary for the day-to-day operation of the business, that is going to be a few $100s. I don't see that requiring a meeting with the partner to say, I just need to buy a box of paper. It doesn't make any sense. But if you need to go ahead and replace all your PCs in the company, requires an investment of, say, $10,000, that's something that probably requires a conversation with the partner, because not only you're talking about replacing all the PCs, but it's also the migration of all that information going from one to the other, and then you got to hire somebody to help you with that. So that's a more involved decision that will affect the company versus something that is routine and customary on the day-to-day operation of the business. why deadlocks are so dangerous, why dangerous to the company, and why can they escalate to litigation. And I'll give you some examples. I mean, one of the things that you can have is operational paralysis, that the company, in essence, is paralyzed because it cannot move forward as to a decision, an important decision has to be made for the company. Uh, you can have a situation where contracts are not signed from vendors, invoices are not paid because one partner does not agree to pay this particular vendor, does not agree with the debt. Uh, Loans will not be approved. In some cases, banks require two signatures to get a loan approved. And you also have a situation that the business itself does not run efficiently. And I've had situations where two partners don't get along, they're in the middle of litigation, they need to make operational decisions because the business is still running, and they are fielding questions through attorneys. And that's just not efficient. You need to be able to have a certain level of speed and efficiency running a business. And if every decision has to be filtered through attorneys, it's just not going to work. And it becomes more expensive because attorneys are going to charge you every time a question is fielded through the attorneys to go back and forth. And the reality, just like a game of telephone, by the time you get an answer back, it might not be the same answer that you would have gotten if you talked to the partner in the first place. So it kind of stalls the business when you have the partners that are not getting along. If you have employees, the employees will see that, and it creates a morale issue that the employees do not know from whom to take directions. And I've had situations like that, that one partner gives a direction to the employees, certain instructions, and then you have the other partner giving a different set of instructions to these employees, and the employees become confused about who to really to obey or to follow instructions from. And then you have a situation that sometimes, and this is very important, then the partner dispute kind of spills over to the employees, and then employees see that the partners are not getting along, and then there's a spat there between them. And sometimes, unfortunately, those discussions or those disputes end up going into a chat, which everybody to see that. So it just creates a very negative situation for the business when you have the employees kind of in the middle of this partnership dispute, and then it goes out in the public, so to speak, through some type of email or Slack channel or chat line that employees may have. So when that happens, employees are going to feel the morale is going to go down clearly, but also they might say, how long will this business be around? And then you might have employees that begin to look for other jobs simply because they don't know whether or not the partners will get along well enough for the business to survive. So those are key things to keep in mind. There's a litigation exposure, and this we're going to what I do. Okay. What happens when this continues to escalate, it becomes emotionally charged. It's like a business divorce. And then one partner decides, you know what, I had enough. I need to get a lawyer because this is not working. One partner gets an attorney, the other partner gets another attorney, and then we begin to start sending letters to each other. A customary letter that one partner makes the allegation that the other partner is taking additional distributions. Usually the accusation is not as sterile as I just placed it. They usually say stealing money from the company. He's taking additional distributions, stealing money from the company. He's locking me out of the company. Those are accusations that I hear. He locked me out of QuickBooks, kicked me out of the bank account. I've had situations where one partner changes the locks on another partner. It becomes that extreme. So, in that case, you usually have one attorney send a letter to the other partner asking for a statutory inspection of records request, which we can ask for. The partner is entitled to all the information. So there's a list of documents that are supposed to be produced within 10 days. Otherwise, you can have a court order enforcing and seeking the request of those documents. Once a demand letter is sent to the partner from an attorney, you're escalating, the dispute escalates even further. Because most likely what's going to happen is that the attorney, the other employee, the other partner is going to get an attorney as well. And then you have now two attorneys involved in a partnership dispute. Usually what happens when I see situations like that, I do recommend, in most cases, a mediation conference before it escalates to an actual filing of a lawsuit in the court. And I'm a big proponent of mediation. And if you have listened to this podcast before, you know that is something that I promote and advocate for. Why mediation? There's a lot of times what the partners need is a third-party mediator that is neutral, that has nothing to do with the case, that they're not involved in anything, to be able to sit down, sometimes through a Zoom call, with the partners and find out what is the nature of the dispute and how it can be resolved. And in many cases, it's the first time the partners ever sat down to discuss why they're not getting along, why they have this dispute. And when people spend 4 or 5 hours discussing the nature of the dispute and how to resolve it, in most cases, the matter gets resolved. And at the very least, there's compromise resolved to the extent that the business can go forward and the temperature has been lowered. And that is the purpose of the mediation. Lower the temperature, and let's see if we can get this resolved. If it doesn't get resolved there, you can always go to court. But one mediator put it to me, and also to my clients, when we were in a mediation conference. She said that, in a trial, somebody's going to win, somebody's going to lose. There's a winner and a loser. It's no draw. And the judge will make a decision. And decision that most likely neither side is going to like. So in a partnership dispute, you have an option. You can attempt to solve the issue yourself on your own terms, meaning the both partners, or you can take that problem to a third party, to another person that has nothing to do with this case, that doesn't care, and have the decision be made for you and place an order to impose you, to make you follow that order. That is a judge. And then they'll move on to another case. So the better option is to try to solve problems on your own terms. Now the solution that might be crafted, or the options, may not be something that be ideal, but it is a compromise. And you're dealing with a partnership, you have a lot of compromises along the way in order to have a successful partnership. And if you cannot compromise in a partnership at all, you better not be in one. So that's a decision that you have to make. But I usually recommend mediation first as a way to try to lower the temperature and see if we can get this resolved to save this business. Because if you're in a partnership, it takes a lot of work to build a business, take a lot of work to sustain the business, and a lot of work to make it successful. But when you have the two owners of the company having a dispute, not getting along, it can jeopardize the future of that business. And then everybody loses. So I just want to give you that for thought. Now, how can you? Well, let me go into something else first. What are the potential claims that can be brought in a partnership dispute? There are a number of options. Say, you go to mediation, it's just not happening. It's an impasse, and when mediation used to be clear, it's a confidential process. Whatever information is shared at mediation cannot be used in a court proceeding, cannot be used as an admission of liability. That's the benefit of the mediation process. It is confidential. The mediator cannot be called in to testify. There's some exceptions, but we don't have to go into that at this point for this purpose of this conversation. The mediator cannot disclose information that was shared at this mediation. And it's a pre-suit mediation, meaning that there's nothing to be filed in court. So usually when you have a lawsuit involving a partner, involves a number of claims. In some cases involves a breach of fiduciary duty, meaning that the obligation you had to protect the business and protect your partner was breached. Involves, in some cases, appointment for a receiver. And what is a receiver? A receiver is someone that, in essence, becomes the de facto owner of the company for a period of time, that takes over the company, runs the company while the dispute takes place. The receiver has to be paid, and it usually comes out of money from the company. And the receiver usually hires a separate law firm to represent the company while the partners are dealing with the dispute. And that law firm has to be paid from the company as well. The receiver also will have access to the bank accounts, clients, everything, through a court order. I've done proposed order for receiverships. It's like a whole page long. And the powers that the receiver have are significant, because then you no longer will own, quote unquote, the company. The receiver will. The receiver will be able to write checks. The receiver will be able to sign contracts. The receiver will have access to the bank accounts, employees, everything. The receiver will communicate with the partners to see any questions how to run the company, but that is one of the claims that usually brought in a partnership disputes, is to have a third party take over the company to protect the assets, protect the company. So that means you're not going to be able to take money out of the company outside of what the salary has agreed upon. A lot of restrictions that come into play. So appointing a receiver is a very extreme circumstance, an extreme measure. The courts take that very lightly. They don't like to do that because that will, for the most part, will be the end of the company. And the receiver has to report to the court on a periodic basis what the results of that, what's happening with the company, and then the receiver will also get paid by the company with the court's approval. So a lot of things going in there. You have sometimes what is called derivative actions. Is DERIVATIV, derivative actions. This is when one owner sues the other owner on behalf of the company. And there's a procedure for that, and we'll talk about that another time. But in this particular case, the owner is suing the other owner on behalf of the company, and then the company is the one that gets the relief. It's not the partner individually. You have claims for temporary injunctions to stop the other owner, the other partner, from taking certain actions, basic access to bank accounts, writing checks, for instance. Usually with those types of petitions for temporary injunctions come a lot of different allegations that have to be made under oath, and they're just not very flattering. And it obviously escalates the situation even further, because usually with that, you also have a counterclaim from one partner to the other. And you also have a You have claims to kick out the partner from the company as well, to redeem the shares for breach of fiduciary duty, for embezzlement, for acts, failure, breach of the duty of loyalty to the company. So you have claims that are included in this type of lawsuit against the partner as well. And last but not least, this is not a comprehensive list, but I just give you the highlights, is a claim for judicial dissolution of the company. The company can be dissolved. So when you have a situation that the partners don't get along and they're in a deadlock, and then there's no possible way to work together, the court can dissolve the company. You have what's called judicial dissolution, and the company can be dissolved. And that's an extreme measure for the court to take. So, in essence, the court orders the business to be dissolved, the assets liquidated, the credit should be paid first, and then you have a situation the court dissolves the corporation or the LLC. That's an extreme measure. That's certainly not recommended, but it's an option the court has. And there's a lot of steps to go there, but that's why we try to recommend mediation first. Let's try to save this company. Let's try to get this resolved. And in most cases, what happens in this case, once you have a situation, you go to a mediation. If there's an agreement, the agreements usually include drafting an operating agreement, so that way this does not happen again. Other options you have is that you can create provisions to have a third party come in and have maybe one share of the company. You have 45, 49, and 49, and somebody having two shares. So that way you have, somebody having two shares, 48, 49, and then in this case, you have one person can be the tiebreaker. Sorry, my math might not be correct, but the point is you have somebody would be able to have the ability to be a tiebreaker, maybe have one or two shares, so that way the person can assist in being the tiebreaker. You have buy-sell provisions as well. One partner can buy the other, and that's including the operating agreement. So there are a number of options that you can have in that could be including the operating agreement in order to avoid the dispute. Number two, if there's a dispute, how to resolve it. And three, if you want to buy or sell, you want to sell your interest, what is the mechanism to sell your interest to the partner, and for how much, or a mechanism to determine the value of those shares. And that is all can be included in the operating agreement. So you have a solid operating agreement. If you don't have one, I highly recommend one. And if you don't have one already, if you want to look at those provisions, I do recommend a step process for resolving disputes. If you cannot resolve the dispute, go to mediation first. That's the first thing you got to do, and it's including the operating agreement before any lawsuit is filed. And if it's in the agreement, most likely it will be followed, because you're going to go to an attorney. The attorney's going to say, can I see the contract, the operating agreement that you signed? And say, okay, you got to go mediation. We'll send the letter to mediation. And that's the first step. 9 out of 10 times, it'll stop there. And other cases, it goes further, but the idea is to prevent the matter from escalating to the point that it goes to court. Is that you go to court, you tell the judge, Your Honor, we cannot solve our problems. We need you to resolve them for us. You're business owners. This can be worked out. If you're in a situation that you're in a deadlock, my recommendation is to try to keep things subjective. Talk to your partner, and try to get the emotional aspect of it out to the extent that you can. Any agreements should be documented at the very least via email. If you had a conversation, say just to recap what we talked about, this is what we agreed upon. You put the points. Have regular meetings with your partner about the status of the business. any issues you got to talk, whether it's a monthly meeting, at the very least monthly meeting. You're talking quarterlies 4 times a year, monthlies you have 12 times, and if you do it bi-weekly, you have more. But frequent conversations about certain topics of the business outside of the day-to-day helps maintain open communication. And if you have a situation you got to make unilateral actions, and you know that this is going to trigger your partner a conversation, just ask first, talk to your partner about the decision you're about to make. I think with open communication, things can certainly be resolved or avoided in the future. And again, my recommendation, as I mentioned before, is to have a solid operating agreement with your company or a bylaws or partnership agreement in order to avoid these disputes. Hope you enjoyed this episode. If you have any questions about anything that I talked about in the podcast or anything specifically about this episode, you can send me an email at richsierra.com. If you would like to have a copy of the operating agreement questionnaire, send me an email as well. Happy to send it to you. Again, it's simply questions that might be helpful to you as well. If you want to give us a call to learn more about our legal services, my number is 866-842-5202. Our website is floridasmallbusinesslegalcenter.com. If you'd like to watch this episode of the podcast via YouTube, we have a YouTube channel. We have several hundred videos posted. Our YouTube channel is youtube.com/@RichardSierra. We're also on Facebook and Instagram at FSB Legal. You'd like to check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.